Ron from Ronald Law, and today we're going to be talking about how to underwrite a commercial real estate lease. So you're under contract to purchase a commercial real estate building, and you understand that the lease is one of the most critical pieces of due diligence because it drives your revenue. It outlines the terms that the tenant and the landlord will agree to make a fair market exchange every month. And you're underwriting your 5, 6, 7% cap rate solely based on that lease or the ability to replace that tenant with a new tenant. Step number 1 is gathering all the documents. And again, that goes even further back to your PSA and making sure that the PSA requires not just the lease, but all amendments, all modifications, any agreements between the landlord and the tenant, which may not be classified as a lease, which may not be classified as an amendment. You want to see all and any agreements between the landlord and the tenant in writing. Step number 2 is going to be reading all the documents, making sure that any of the referenced amendments are all included in your package. I see that time and time again. You have the main body of the lease. It's going to reference 6 different exhibits, but I only might get 4, or I might get an incomplete exhibit 3 that has the first page and not the second and third. So again, once you get that due diligence, double check it and make sure that all the exhibit pages are there. And then secondly, start reading it. And you've really got to read it line by line. There is no such thing as a form lease. No 2 leases are the same. Particularly pay attention to termination rights. You want to see anything that gives a tenant a right to terminate and go for the nuclear option of just getting out of the lease. You might underwrite based on the remaining 3, 5, 6 years on the lease, but if the tenant has the ability to terminate, that throws up a huge red flag, and it's just gotta be aware of what are the conditions that the tenant could terminate this lease and cease all cash flow. Or maybe there's a fee, and maybe you understand that and you're okay with that trade-off, because if a tenant does have an early termination option, there's usually a fee to accompany that right. I'll say usually, sometimes. In addition, when we're looking at the lease, we want to look for what the payment obligations are of the tenant, the timing, the amount, the calculation, the method of dispute, offsets, any reason to affect the money. And I think that we really just focus on the money because that's my first priority, is to make sure I understand what are the obligations of the tenant to pay, and similarly, what are the obligations of the landlord? And that's an area too that has a lot of gray area, where the landlord can be a true absolute triple net, where they don't even see the property tax bills, they don't even know what's going on with the property, versus they may have more of a hybrid and they have to maintain the road. They may have to maintain a parking lot. They maintain payments to a master association. Maybe they have to do the building envelope. Maybe they're responsible for windows and light bulbs. There's all sorts of degrees of responsibility for the landlord. And as a new buyer who's stepping into the shoes of the landlord, it's critical that you understand what your obligations are. And that's kind of rolling over to the second part, is what are the non-financial obligations? And that can, again, be a whole host of tenant obligations. Keep the premise open. You want them operating 24, maybe not 24 hours, but you want them opening during business hours, 5, 7 days a week, whatever the requirements are. You want to understand what your expectations are of the tenant, to not put signs up, not to host sidewalk sales. There's all sorts of acts or clauses which limit the acts or behavior of the tenant. There's some catch-all language that will maybe say in compliance with all local laws. Well, what does that really mean? If you as a landlord are out of state, you don't know what the local laws allow or prohibit. And so if you're purchasing a shopping center, the whole nature of your shopping center may be subject to local laws and customs. That's a big range. And I think a lot of owners want to know a little bit of the restrictions, or what the base minimum, the common denominator is for behavior if you're trying to reposition a shopping center and make it into something better. Well, if tenants have the ability to do X and it's not within your scope of the new shopping center, then it's really critical that you work that out ahead of time and have a plan to address it, because if tenants have a right, you have to assume that they're going to exercise. You cannot rely on status quo. And I can't tell you how many times I've had people come to me after they close a transaction and they say, what do I do? The tenant is doing something and I don't like it. Maybe they're posting discount signs, or they're storing furniture in a parking lot stall, or their employees are parking in the customer spots and neighboring tenants are complaining. If it's not in the lease and it doesn't expressly prohibit that tenant from doing something, you're in trouble. You've got to find another way to address their behavior, but understand that the landlord is in a tough spot when they don't have it spelled out in the lease. Beyond that, I look at guarantees, whether there's a personal or corporate guarantee. Really, really critical part of the underwriting process, because they have to know who is guaranteeing this lease, if anybody, right? And just because a broker tells you, oh yeah, there's a guarantee, there are various circumstances where the corporate or the tenant, the personal guarantee doesn't apply. Maybe it's burned off. Maybe it's been waived. Maybe that corporate or personal guarantee has burned down over the course of time, and while it was signed initially, it's no longer in place or enforceable. There also could be conditions or limitations on when that corporate guarantee needs to be exercised, or it could have a limitation on the financial amount. So another great example is corporate guarantees could only guarantee the payment of base rent. So for a triple net building, that can be a majority portion, but call it 70%, call it 85% of the total payments from the tenant to the landlord. And the corporate guarantee will not guarantee operating expenses, late fees, penalties, attorney's fees, all reasonable charges, but not being counted under base rent. And that's a big distinction if you're thinking that no matter what, this tenant has a corporate guarantee. Not all the same. There can be a carve out for that corporate guarantee to only pay base rent. In addition, there might be some qualifications on when they have to pay. And just because a tenant goes dark, if they exercise some other clause in the lease, they may still be paying rent, but they're going dark, or they're technically open, but they're not performing. The tenant might try to stretch out the trigger of that corporate guarantee, and then it might take them 90, 180 days to pay. Something like that is just something to be aware of, and making sure that you understand, if I have to exercise this corporate or personal guarantee, how do I do it? How long does it take, and how much does it cost? Because guarantees, not all the same, but brokers like to tell you, don't worry, this lease is secure. It's 100% backed by this guarantee. Really not the case, and you need to dig into each lease to find out what is expected and how do you underwrite in the value of that property. I've tried to cover a couple of the top areas. These are what I would call the top 3 or 4 areas of a commercial lease that we look for. If you have any questions, feel free to drop a comment below and I'll respond as soon as I can. But smash that like button and subscribe for more commercial real estate content. Until next time.